Get ready. Start. 28. Before proceeding further, it may also be mentioned that it was only respondent number 3 who had approached this court by filing a writ petition under Article 32 of the Constitution of India, being writ petition in bracket CRL number 135 of 2022, seeking a direction to the state of Gujarat to consider his premature release, full stop. None of the other convicts, that is, respondent number 4 to 13, had approached this court or any high court seeking such a relief, full stop. Therefore, insofar as these respondents are concerned, there was no direction of this court or any court to the state of Gujarat to consider their premature release, full stop. We are of the considered view that the writ proceedings before this court is pursuant to suppression and misleading of this court, full stop. Hence, in our view, the said order was obtained by fraud played on this court and hence is a nullity and non-est in law, full stop. In view of the aforesaid discussion, we hold that consequently the order dated 13/5/2022 passed by this court in writ petition in bracket CRL number 135 of 2022 in the case of Bhagwan Das Shah is hit by fraud and is a nullity and non-est in the eye of law, and therefore cannot be given effect to, and hence all proceeding pursuant to the said order are vitiated. Paragraph change 29. It is well settled that writ jurisdiction is discretionary in nature and that the discretion must be exercised equitably for promotion of good faith, while State of Maharashtra versus Vijay Kumar in bracket 1994 to SCC 481, full stop. This court has further emphasized that fraud and collusion vitiate the most solemn precedent in any civilized jurisprudence, and that fraud and justice never dwell together, full stop. This maxim has never lost its luster over the centuries, full stop. Thus, any litigant who is guilty of inhibition before the court should not bear the fruit and benefit of the court's order, full stop. This court has also held that fraud is an act of deliberation with a desire to secure something which is otherwise not due, full stop. Fraud is practiced with an intention to secure undue advantage, full stop. Thus, an act of fraud on courts must be viewed seriously, full stop. Further, fraud can be established when a false representation has been made in bracket Roman 1 knowingly, or in bracket Roman 2 without belief in its truth, or in bracket Roman 3 recklessly, being careless about whether it be true or false, full stop. While suppression of a material document would amount to a fraud on the court, suppression of material facts vital to the decision to be rendered by a court of law is equally serious, full stop. Thus, once it is held that there was a fraud in judicial proceedings, all advantages gained as a result of it have to be withdrawn, full stop. In such an eventuality, doctrine of res judicata or doctrine of binding precedent would not be attracted, since an order obtained by fraud is non-est in the eye of law. Full stop. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim.